This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today is the Zalma Philosophy on Claims Handling, Part 3, which deals with the California Fair Claims Settlement Practices Regulations and the reasons why the California Department of Insurance imposed the regulations on all insurers doing business in the state of California. In 1993, after delaying for 5 years after receiving directions from the California Supreme Court, the state of California's Department of Insurance determined that the insurance industry needed to be regulated to stop insurers from treating the people insured badly and without good faith. It created a set of regulations called the California Fair Claims Settlement Practices Regulations that were designed to endorse and enforce the mandate created by the California Fair Claims Settlement Practices Statute, California Insurance Code, Section 790.03H. In response to the direction of the California Supreme Court in its decision entitled Moradi-Shalal versus Fireman's Fund Insurance Company, a 1998 decision, the great majority of state versions of the Model Act that, like the California Insurance Code, have been held not to create a private cause of action, and that was the reason for setting up a set of regulations. The Supreme Court of California advised the state that, quote, "We observe that our opinion leaves available the imposition of substantial administrative sanctions by the insurance commissioner," close quote. These sanctions included issuance of cease and desist orders to enjoin further violations of Section 790.03 and monetary fines. They could put them right out of business if the department wanted to. The California Department of Insurance, the CDOI, issued rules that were designed to micromanage the business of insurance claims and create a method to punish those insurers who failed to comply with the regulations. Some of the regulations recited what had always been recognized by the insurance industry in California as good faith and proper claims handling, the basic custom and practice of every adjuster working in the state. Others imposed draconian paperwork on what and when to do everything in the claims process. The regulations also provided a guide to insureds, public insurance adjusters, and policyholders' lawyers to assert any violation of the regulations, which set minimum standards, to be evidence of an insurer's breach of the implied covenant of good faith and fair dealing. The CDOI issued the first version of the regulations in 1993 and modified the regulations in 1996, 1997, 2004, 2007, 2009, 2012, and 2021. The 1997 changes renamed the regulations as the California Fair Claims Settlement Practices Regulations, which name remains. The regulations imposed on all insurance personnel a detailed laundry list of actions the CDOI determined and considered wrongful or in violation of the Fair Claims Settlement Practices Act. The regulations impose on all insurance claims personnel the requirement that they read and understand the regulations or attend an annual training program no later than September 1 of each year. Insurers are compelled to ascertain that every employee involved in any way in the claims process is trained about the regulations or has submitted a sworn statement that he or she has read and understands the regulations. The regulations even require that the insurance claims managing executive attest under oath that each employee has been trained with regard to and or understands the regulations. The requirement must be complied with in order to avoid the possibility of administrative penalties upon the insurer or prosecution of the officer for perjury. Whether in California or not, it is useful to every claims person to study and follow the regulations to become a professional claims adjuster, because these provide minimum standards for a professional adjuster. For a complete understanding of the California Fair Claims Settlement Practices Regulations, you can see my book, California Fair Claims Settlement Practices Regulations 2022, which is available as a Kindle book and a paperback from Amazon.com and at the link provided in the blog post. Part 4 of the Zalma philosophy of claims handling will deal with what is required by the regulations that have codified the custom and practice of the insurance claims industry in California. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,200 blog postings. You can also subscribe to these videos on YouTube and rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.